Anyways, I will now introduce the speakers. First up is Professor Josh Blackman, who is a national thought leader on constitutional law in the United States Supreme Court. His work was quoted during two presidential impeachment trials, and he has testified before Congress and advises federal and state lawmakers. Josh regularly appears on TV, and he has published commentaries in leading national publications. Since 2012, he has served as a professor at the South Texas College of Law, Houston, where he holds the Centennial Chair of Constitutional Law. He is also an adjunct scholar at the Cato Institute, and he has authored three books. His latest, which is called An Introduction to Constitutional Law, have it right here. Really great book. It was a autographed. It was a top 5 bestseller on Amazon. Josh has written more than 6 law review articles, and he has been cited nearly 1,000 times. Lastly, he was selected by Forbes magazine for the 30 under 30 in law and policy. And then next up, we'll then have Professor Michael Dorf from Cornell Law School. He has authored or co-authored well over 100 scholarly articles and essays for law reviews, books, and peer-reviewed science and social science journals. Just to name one of many works, he is the co-author of On Reading the Constitution. Professor Dorf writes a bi-weekly column for Justia's web magazine Verdict, and he posts several times per week on his own blog, Dorf on Law. I'm sure all of his students is well aware of that. He is also an occasional contributor to other magazines, newspapers, and blogs. And lastly, he is a graduate of Harvard College and Harvard Law School. After law school, he served as a law clerk for Judge Stephen Reinhart on the Ninth Circuit, and then Justice Kennedy from Supreme Court of the United States. Thank you both for being here, and Professor Blackman, take it away.
Thank you so much, George. It's a pleasure to be here. I was actually last in Ithaca in the fall of 2019. It was a good visit. I had lunch with Mike and Sherry, who I miss dearly, and I miss her commentary. So good to see Mike, at least virtually. Originalism, right? This is one of those topics that seems to get a lot of attention in the academy. But when it gets to the Supreme Court, they don't always get the memo. They sort of do their own thing. So I want to talk about Bruin, which was a recent Second Amendment case. I want to talk about Rahimi, which was a case involving the Second Amendment and domestic violence. And then I want to talk about what the court might do or probably will do as this case is pending. So let's get some background. In the span of 2 years, the Supreme Court decided two landmark Second Amendment cases. DC v. Heller in 2008 held that the Second Amendment guarantees an individual right to keep and bear arms that is not connected to militia service. 2 years later, McDonald v. Chicago applied this right to the states through the 14th Amendment. The precise holding of both cases, however, was limited to the issue of whether the federal and state governments could prohibit the private ownership of handguns inside the home, not outside, inside. Heller and McDonald did not address a broader question. Does the Second Amendment guarantee a right to carry a firearm outside the home? 12 years passed, it's almost a bar mitzvah. The lower courts would divide on this question. Finally, in 2022, the court resolved it. The court held the Second Amendment does protect the right to bear arms outside the home, Bruin. This was not a hard ruling. It was probably an easy ruling to predict, but how they got there is significant. So the facts were Brandon Koch and Robert Nash were citizens of Rensselaer County. Is that near you, Rensselaer County, Mike? Okay, good.
It's not that close. It's near Albany, so
Okay.
it's like a little under 3 hours away.
I grew up in Staten Island. It's all upstate to me. It's just this nebulous region that we never actually ventured to. They were in Rensselaer County, and they were members of a New York State Rifle and Pistol Association. They both wanted to carry a handgun outside their homes so they could defend themselves. But New York required more. New York had what was called a may issue regime. What that means is you must demonstrate, quote, proper cause to carry a firearm. This was, under the law, a special need for self-protection distinguishable from that of the general community. It was not to show that you had a high crime area where you lived or work. You needed more particular threats, attacks, or extraordinary danger to public safety. The fact is, most people who applied for these probably were denied unless they had some sort of special connection, and there's a lot of that in New York. Celebrities had a high rate of grants of these permits, as it turns out. That was a may issue state. More than 40 states, depending on how you count, have what's called a shall issue state. What that means is if you pass whatever objective criteria there are, a background check, a training course, you will get your license. There's no discretion. Coach and Nash had no special need, so they challenged it. In the district court, the court found that this was constitutional. The Second Circuit upheld it. Went to the Supreme Court. Court reversed by vote of 6-3. And Justice Thomas wrote the majority opinion. It was joined by, as you can probably predict, Chief Justice Roberts and Justice Alito, Gorsuch, Kavanaugh, and Barrett. Breyer wrote the dissent, joined by Sotomayor and Kagan. And this was actually Breyer's either his last or second to last dissent of his career, because he would resign from the bench shortly thereafter. So this one was his last cases he decided. There were 5 primary issues in this case. The first is methodology. In the decade after Heller and McDonald, the lower courts reviewed gun control laws with either strict or intermediate scrutiny. Justice Thomas's majority opinion rejected any means-ends balancing. Instead, the court favored a test rooted, and they love this phrase, in the Second Amendment's text, as informed by history. It's always text and history. They always put those two together. And under this test, the government has the burden to affirmatively prove that its firearm regulation is part of the, here's the key phrase, historical tradition that delimits the outer bounds of the right to keep and bear arms. So again, we have text, we have history, and we have this thing called historical tradition. What does tradition add that's not in history? If like Fiddler on the Roof, tradition, right? It's not entirely clear, right? Except for the fact that history seems to be contemporaneous with 1789, whereas tradition is stuff that came later. You speak of a deeply rooted tradition in the Glucksburg context, perhaps, but tradition is not limited in time to when the text was ratified in 1789, or perhaps, yes, Justice Barrett, 1868. It could be stuff that comes later, okay? Next, the court will assess whether modern firearm regulations are consistent with this text and historical understanding. Justice Breyer, who is no originalist, said that this is not the way we should decide cases. He says that we are not equipped to resolve these historical surveys. There were professors of history who ran departments in the English Civil War who said that Heller was all wrong. And Breyer says that this is a case showing both sides. I don't know how to deal with this history. And so how does Breyer resolve the tension? He says, in the event of a tension between these professors of history and so on, we should defer to the government. In other words, instead of applying maybe a tiebreaker for the individual, the tiebreaker goes to the state. And Justice Sotomayor said that there's a long-standing tradition of carrying weapons and laws that ban that. The state gets deference. But Justice Thomas disagreed. He said the courts resolve legal questions rather than resolve historical questions in the abstract. When parties present courts with historical record, courts can decide based on which party made the stronger case. Okay. The second part of the opinion. The court held that the Second Amendment protects a right to carry a handgun outside the home. New York didn't actually dispute this point. This is significant. New York agreed the Second Amendment extended outside the home. It doesn't draw a public-private distinction. Instead, they disagreed on the standard by which permits could be granted. Okay. Thomas said the text has 2 components, keep and bear. Keep and bear. And the word bear naturally encompasses public carry. And confining the right to bear arms in the home would nullify half the Second Amendment's protections. Moreover, the need for self-defense takes place outside the home, not so much inside the home. I suppose it can with invaders and the like. So next, the court turns, I think it's probably the most controversial part of Bruin, what it calls analogical reasoning. Do you all take the LSAT, the SAT? Remember this? Or if this is to this and this is to that. Remember those questions that sort of drove you crazy? This is sort of what the court adopted. And I want to just make this point at the outset. I've read the amicus briefs in this case. I read the literature. I think I know the people involved in this litigation. No one proposed this form of reasoning. Not a single amicus brief, not a single law review article, no one. Now, after the fact, people started defending it because it's there and you have to defend it, right? But, ex ante, I don't remember seeing this mode of reasoning developed in any brief. Maybe Mike has seen it. I don't recall. And I see the dog in the background. Very good. Okay, so how does this analogical reasoning work? So during the oral argument, Paul Clement was arguing. And Thomas says, if we analyze this with history, tradition, and text, we're going to do it by analogy. So, for example, he said, can you give me a regulation history that would form a basis for regulation today? In other words, if you want to regulate X today, is there some analogy to a regulation in history where they regulated X, or maybe something close to X, and the closeness becomes actually an important delta. So Justice Thomas looked for analogies in 4 periods of time. The first period of time was medieval times. You would go there. There's one by Giant Stadium. It's not called that anymore. I think it's in Newark somewhere, right? Medieval times is a great place. You can see jousting the like. So look to the 1328 Statute of Northampton. Okay. This statute, if you read it, it says people cannot go armed. Going armed is the phrase in the statute. And this law was enacted in the reign of King Edward III. You probably never heard of him. That's fine. So is this an analogy for the law that New York has imposed? So Paul Clement disagreed. He said, no. This statute was not a ban on carrying. It was a ban on using weapons to terrorize the public. So to use the phrase, might be assault, might be brandishment, something like that, but it was not straight up a ban on carry. Barbara Underwood, who's she's still the SG in New York? I think she is, right? Maybe not. Anyway, she was the SG in New York, at least at the time, said that no. Carrying a gun by definition terrorizes the public. Basically, it's like a per se rule. So banning weapons would, of course, include banning weapons, whether it's used in an offensive or non-offensive manner. But the court agreed with Clement and said the Statute of Northampton is not a good analog, an analogy for the New York law. Next, they went to the American colonial era and the early republic. They said there was little evidence of regulating public carry in that period. Okay, we jump forward to the antebellum era, that's before the Civil War, and state governments did enact restrictions on public carry, but Thomas said none of those restrictions impose a substantial burden on public carry that were analogous to New York's regime. At most, they regulated the manner of carry, but not the right to carry altogether. So you see, the rub with this analogy is how close is the fit, right? If you think of scrutiny, right? How close is the fit between the historical law and the law that New York has implemented on its own, right? If we just take a general definition, were the regulations that carry? Yeah, there were. But Thomas wants precise, that it must be a regulation of the manner of carry, not just carry in the abstract. Okay. Next period of history is after the Civil War. This, maybe you know this, but a lot of gun control laws actually were born after the Civil War as a way to disarm the freedmen. These were racist Jim Crow laws to prevent blacks from defending themselves in armed conflict with the Klan and the like. So Thomas says, yes, there were plenty of laws designed to keep blacks' rights to bear arms, but these are not good evidence of how the 14th Amendment was understood. And during the argument, the SG said, we're not relying on these racist laws as evidence. The government's relied on them in lower courts. They said, we don't want to talk about that now because it's a bit uncomfortable, right? There's a right to bear arms, but black people can't have this right. In fact, if you read the Freedmen's Bureau, which is an important statute passed in 1866, it says, among the rights are the rights to bear arms. It lists that front and center. And if you ever want to read an awful case, U.S. versus Crookshank, I don't know if you guys teach that in common law, but involved a terrible massacre of freedmen. They basically burned down a building with these people alive in them because this was a group trying to defend themselves against a mob. A dreadful case, but the Supreme Court said that no, they don't have Second Amendment rights. All right. According to Justice Thomas, limits on carry in other states were still consistent with the right to peaceably carry handguns for self-defense. Another hard spot for Thomas was the Western Territories. You've probably seen these pictures, like the Old West, with a sign that says, enter the town, but leave your gun with the sheriff. I think that was in Back to the Future Part 3. You've probably seen this sort of thing. These signs were everywhere. And as Thomas deal with this, he says, well, these were not really states. They were territories. They were not yet mature jurisdictions. This is not part of an enduring regulation of guns. Okay, maybe you like that, maybe you don't, but he addresses it. So Thomas concluded that American governments simply have not broadly prohibited public carry of commonly used firearms for personal defense. But there's another history it doesn't mention, which is New York. New York's law was over 100 years old. That's a long time, right? I mean, that's, it's not nothing, but it's 100 years. It was enacted as part of the so-called Sullivan laws, which were, again, racist laws designed to disarm immigrants, mostly Irish at the time. But New York's law is around for more than 100 years. That tradition Not long enough for Thomas. Okay. This is a problem with the historical analogy, right? How close of a fit, how far back do you go? This, again, is not what most originalists would advocate using when you're deciding the Second Amendment, but we got there for reasons I'll talk about in a few minutes. Okay, so in the bottom line, the proper cause standard was deemed to be unconstitutional. Okay, part 4. This is where the court sort of goes off the originalist rails, as often happens. He says, well, but there are limits on the holding, right? We're not casting doubt on the shall-she laws in 40-odd states. You can require a background check, safety course, and the like. But these must be objective standards. Okay. By the way, the wake of Bruin, New York now, I think, has basically a good citizenship stamp. Maybe it's New Jersey, but basically you have to be like a good citizen, you know, good character, which I think might also have problems. But Bruin said you need to have objective standards. Is good character objective? We'll see what happens. Okay. But they said that other regimes may be unconstitutional if there are long wait times or fees. Okay, Justice Kavanaugh wrote a concurrence because he can't resist. And he says there are more limits on the court's decision. For example, background checks, firearm training, and mental health records. That wasn't New York's law. I can't imagine why Justice Kavanaugh would worry about people who with mental health issues carrying guns inside the home or his home. Kavanaugh also repeated the paragraphs from Heller that approved of the so-called long-standing prohibitions of firearms by felons and the mentally ill, as well as laws forbidding the carrying of firearms in sensitive places. These were 2 dictum/holdings from Heller that were very important, that you can ban carrying in so-called sensitive places, and that you can have long-standing prohibitions on firearms by felons and the mentally ill. The Supreme Court has not defined what sensitive places mean. This comes up all the time. The 5th part goes to Justice Breyer's sort of wheelhouse, and I miss Justice Breyer. I do. I miss his questions and argument. I didn't quite know how much I'd miss him, but I do miss him a lot. It's like family, right? You miss the guy. Justice Breyer has then highlighted how many Americans were killed with firearms in mass shootings. He had all the he loves statistics. He had all the statistics in his paper about all the mass shootings and the like. And he said that this opinion will severely burden states' efforts to reduce gun control law. So again, he says judges exhibit modesty and restraint in the Second Amendment context. Justice Thomas said no. Other rights have public safety implications. This is important for Rahimi. Other rights have public safety implications. Do you judge a right based on how it might affect the public? All right. So let's jump ahead to Rahimi. It arose where else? My beloved Fifth Circuit, and involves a guy named Zaki Rahimi. This is not a good dude. He engaged in a lot of bad behavior. He beat up his girlfriend. He shot at people. He apparently didn't hit them. I guess he missed, but he shot at people at least, and engaged in some pretty bad conduct. A Texas court enters what's called a DVRO. DVRO. That's Domestic Violence Restraining Order, DVRO, which says that while this order is in effect, you can't go near the domestic partner, you can't, engage in any threatening behavior over the phone or social media, and it also says you can't possess a firearm. Okay. There's also a federal statute that makes it a crime to possess a firearm while you're under a DVRO. Again, a DVRO is entered by a judge. It might be ex parte, there might be a hearing, but it's not like a full criminal trial, right? You're not indicted, there's no conviction, and so on. In fact, Rahimi was never actually convicted of these various offenses. Why? I've not found a good answer. I think this man should be in jail. He should not be on the street, but what do I know? But anyway, the good people of Texas let him out. They did not indict him. They did not put him under bail. And that's why he engaged in the behavior he did. So he basically had a gun while he was under the DVRO, and he was indicted and was convicted. His case sort of floated around the courts for a while, and after Bruin went back down, and my beloved Fifth Circuit held that the Second Amendment protects a right to bear arms. And merely because you're dangerous, right, and you've been accused of being dangerous, is not enough. And here's the important point, right? The Fifth Circuit panel said that there's no tradition of the government depriving the right carry arms to people who have been accused of domestic violence. And I already see Mike is wincing at this. Um, you know, there's also not a very long-standing tradition of enforcing domestic violence laws, right? Now there is. Now I want to be careful. There were a number of states and colonies that made it a crime to engage in domestic violence. I don't know how rigorously it's enforced, but these were crimes. You could just beat up your wife most of the time, perhaps. There's argument to the contrary, but there's not an enduring tradition. So before I go on to talk about Rahimi before the Supreme Court, I just want to say that I think Rahimi, the Fifth Circuit panel, faithfully applied the precedent. I think they did. And if Rahimi is reversed, it's not because the Fifth Circuit screwed it up. It's because the Supreme Court wrote an opinion in Bruin that either they didn't mean, or they didn't fully appreciate the consequences of what they were doing, or now they perhaps have second thoughts about it. Maybe all the above. Right. But again, there is not a tradition of banning firearm usage for those who engage in domestic violence. Again, if there's a conviction, I think everyone agrees you can disarm them, I think, especially for a violent felony. Okay. So the case goes to the Supreme Court, and it did not go well for the lawyer for the Supreme Court. Mr. Rahimi was represented not by Paul Clement or someone else. He could have been, but he chose not to. He was represented by a federal defender from Northern District of Texas. And I don't mean this to criticize federal public defenders. They do a very important work, and it's very hard work. And they're overworked and they're underpaid. And I have all the respect in the world for public defenders. Please don't take me wrong. My point is, the Supreme Court didn't really care about Rahimi in particular. They want to put a rule in that would apply nationwide, all 50 states. And a criminal defense lawyer is focusing on his client's interests, which might be at odds with the broader Second Amendment sort of gestalt, right? Those are not always lining up. So the arguments being presented, I think, were, as they should have been, aimed at Mr. Rahimi's case, but it left other things under the table, right? For example, Chief Justice Roberts asks, is your client dangerous? And the guy kind of like hemmed and hawed. And the answer is, of course he's dangerous, but that's not the question, right? You have to pivot. And I think the lawyer was arguing for a case, and I think he did the best for his client, but that was not what the court probably wanted. So whether the court rules, however the court rules, I don't think it much matter what the lawyer said. But I think Rahimi will lose. It might be 7-2, might be 8-1, might even be 9-0. I don't know. Might be 6-3. I don't know. But I think they might actually get Alito to vote with majority, because it's again a pretty dangerous person. The trick, though, is what test gets applied. And during the arguments, Justice Kagan, asked for some useful guidance. Right? She asked the Solicitor General Prelogger, who actually was a former clerk. She's very, very good, by the way. Prelogger, excellent lawyer, very good lawyer. What's some useful guidance that we can follow? And then Prelogger gives this answer, which I think is very important for originalism. And she repeated this answer like verbatim several times. So, she had it drilled into her brain, because that's what Supreme Court advocates do. She said, I'll read it to you. She says, the way constitutional interpretation usually proceeds is to use history and regulation, ready, to identify principles, the enduring principles that define the scope of the Second Amendment right. So she's taking this text and history tradition and using them to identify principles, not drawing analogies to specific laws that were enacted in the past, but sort of gleaning broad principles, enduring principles that define the scope of the Second Amendment. That is a repudiation of Bruin, right? I mean, that's not what Thomas said at all. But this seemed to sort of gain purchase from several of the justices who might be getting cold feet on Bruin. So if the court says we will look for broad principles, they say, look, in Bruin, almost every state allowed carry, right? And they did this. And there's broad principles you can carry outside the home. But there's not a tradition of people who are dangerous carrying arms. And this is why the level of generality matters. If you say, is there a tradition of banning people who've been accused of domestic violence of carrying a gun with a DVRO? Well, the answer, of course, is not, because these things didn't exist. The idea of a DVRO is a modern innovation. But if you say, is there a tradition of people, is there a tradition of people who are dangerous, even absent a conviction, from being denied the right to bear arms? That's harder, because usually you would only have people disarmed after a conviction. But let's say you say their level is, could dangerous people have guns? That's your level of generality. The answer is probably not. You can make a principle at that one. So a lot turns on what level of generality, how precise your principle must be. Justice Thomas and Bruin wanted like SAT level, precision with the historical analogies. That ain't what Prelogger described. Now this might have purchase in the court, not because it's a faithful application of Bruin, but I think it allows the justice to sort of, show face. And they can say, well, Bruin's great, but we didn't have occasion to decide who dangerous people are. This is different. And they might even say, if you are a white-collar felon, Martha Stewart. Mike, do you know who Martha Stewart is? Yes, Martha Stewart, right? She went to jail for a number of years for obstruction and like, yeah. Anyway, so but she's basically this domestic TV person, engaged in some potential insider trading, had obstruction. She went to jail, but she's not dangerous. Why can't Martha Stewart own a gun? Martha Stewart is not Zaki Rahimi. So the court might say, well, if you're a non-violent felon, then maybe you can have a gun, but not violent felons, and also not violent people who are just accused who have never been charged. I think that's probably what the court will do. One just wrinkle of this is they might say, when you have a constitutional right that leads to dangerous things, we have to read it maybe narrowly or something like that. Well, there are lots of dangerous rights, the rights of confrontation, let people out of jail. The Fourth, Fifth, and Sixth Amendments can have exclusion of evidence. They can have convictions tossed out. In many regards, the Constitution is designed to protect dangerous people. And that's not fun to say, but we have a lot of rights that are there because people are not so pleasant. I mean, if I'm teaching First Amendment this evening, a lot of the early First Amendment cases were involving sedition, right? People who were trying to say oppose the draft, oppose the war. They were engaging in conduct that was deemed dangerous to the government. So there's that, but also domestic violence is different. And people think domestic violence has to be treated differently. Justice Kavanaugh in particular, you can probably imagine why. And I think the court will just be constrained, which is why I think this actually might be even 9-0, if that way one of the conservatives can write the opinion and at least try to save or salvage as much of Bruin as possible. I don't know if they'll be able to. But in some regards, the Fifth Circuit gave a gift to the government by making this the key case. There are other cases. Another case in the Third Circuit involving a guy with food stamp fraud, right? Food stamp fraud is bad, but who really cares? Can a guy who engaged in food stamp fraud have a gun? He should be able to. But the Supreme Court did not grant that case. They granted this case. And they could have heard them together, but they didn't. So we'll have Rahimi alone, and maybe the food stamp case in a year or two when this goes on remand. All right, I am at about 30 minutes. I want to pause here and give my good friend Mike some time to talk, and I'm welcoming your questions later. Thank you all so much.
Okay, so I'm just going to jump in. I will try to keep this. I don't know. How late do we go, George?
Well, ideally we should wrap up around 6 o'clock, but we could take questions.
Okay,
from
so
them.
yeah. So I'll take no more than 15 minutes, maybe even less, so we can get to questions. So first, I want to welcome Josh and thank him for joining us. Josh and I often disagree, but we have great mutual respect for each other, and we actually often end up writing about the same issues because we have very similar interests. In fact, often our analysis will be like 95% in agreement, and then we just disagree about the conclusion. Yeah. So it's great. It's great to engage with you. Thanks for coming here. I agree with nearly everything that Josh said, which I think is mostly descriptive and analytical, rather than, I didn't see it as sort of strongly normative. I want to register one slight addendum with respect to one of the descriptive points, and then I want to try to step back a little bit and try to put the questions in a somewhat broader context. So the one place I would sort of add an additional point is the kind of guilt by association point that Josh was making with respect to some of the gun control laws, that the post-Reconstruction laws or post-Civil War laws were aimed at disarming, much lesser extent, freed women, that some of the other laws were rooted in anti-Irish sentiment. And the point I want to make is that virtually everything from earlier eras was rooted in the prejudices of its time. So I think you'd be able to find that with respect to laws about just about everything. And there's at least some literature suggesting that the Second Amendment itself was adopted chiefly because, as you'll recall, the fear was that the federal government would displace state militias, and that the southern states wanted to maintain robust state militias, in no small part to be able to repress slave revolts. And so, you can play the guilt by association game, but I think we have to take the laws more or less as they stand. Okay, that's a small point. The bigger point is that, as you may have seen, the flyer for this program was about originalism and Bruin and maybe Rahimi. And I want to just make the point, which I think is consistent with what everything Josh said, that Bruin is not originalism. So originalism, as I'm not an originalist, although I'm very interested in original meaning and history, and I think those are important elements of how one properly goes about construing the Constitution. But as I understand the writings of my originalist friends, there are two primary flavors of originalism, and then sub-flavors. And I'll mention the primary flavors in just a moment. And then I want to say that Bruin isn't either of them. So the old school originalism, the OG originalism, if you will, relied on the so-called original intent of the framers and sometimes the ratifiers, right? The question, if you want to know what does the Second Amendment mean, you would ask, well, what did they intend it to mean, okay? And this view, which was, I think, dominant in general, even in the academy, until roughly the early to mid 1980s, was subject to very severe criticism, mostly having to do with two things. One, that it's often very, very difficult to figure out what a collective like the Congress that proposed, the states that ratified, the people that voted for the ratifiers thought about anything, or even with respect to the original Constitution, right? The convention met in secret, deliberately so. The ratifying debates are incomplete with respect to all sorts of things. So there was a question about how do you determine original intent? And then there was a second sort of withering criticism about just the nature of legal obligation, which is that, as Justice Scalia once said in a statutory context, we're governed by the laws that our lawmakers, I'm paraphrasing, but this is the Omcal case and a Title VII case, we're governed by the laws that they write, right, the words they chose, not by their intentions. And so most scholars of originalism, beginning, as I said, around the mid-1980s through the present, shifted away from an originalism of subjective intentions and expectations and towards what is sometimes called the original public meaning of the words, right? So if one wants to know what do the words keep, bear, arms, militia, etc. mean in the Second Amendment, you consult dictionaries, you consult what are now becoming more popular, a corpus, which is a collection of all sorts of usages from the time. You figure out what did the words mean, and that will give you a sense of what a typical well-informed person of the day would have understand to be the communicative content of the phrase that was then ratified and made law. What's notable, as I say, is that, so we've got original intent originalism, and we've got original public meaning originalism. It's very, very clear that Bruin is not original public meaning originalism, in that, right, there's no effort to sort of zero in on the semantic content of the words. It's not a canvassing of 18th century, or as if you think of it as, because it involves a state, therefore it's the 14th Amendment, of 1868 era dictionaries. There's no effort to do any of that, right? And so it's not original public meaning originalism. but neither is it original intent originalism, right? Now it's connected. I think it's related to original intent originalism. That is to say, if you wanted to know, well, what were they getting at? You might want to know, well, what did they think was permissible? But you would need at least an additional bit of connective tissue to get from the laws that they enacted to what they intended. I'll just give you a sort of straightforward example involving the First Amendment. It is now sort of conventional wisdom that the First Amendment made the Sedition Act unconstitutional. At the time, that was the view of Thomas Jefferson and of most of the members of his political party. It was not the view of Adams and the Federalists. There was a contest. I think we side with the Jeffersonians for primarily because we like their view. We think it's a better understanding of the First Amendment that you can't lock somebody up for saying something critical of the government. And in that sense, we side with Jefferson for completely non-originalist reasons. But you could think that Jefferson had the better view of both the original public meaning, right, and the original intent of the framers and ratifiers, and that nonetheless, Congress went ahead and enacted a law that was inconsistent with it. I'll give you another more contemporary example. So when Congress was debating the law that was eventually put to the test in the Boumediene case in 2008, Senator Arlen Specter, who was a senator from Pennsylvania, he had been a Republican for most of his career. Then he switched near the end of it. But he was a pretty good constitutional lawyer. But he was also a bit of an opportunist. And he gives us an impassioned speech on the floor explaining why he believed that the relevant provision of the Military Commissions Act that stripped federal courts of the power to grant writs of habeas corpus without suspending the privilege of the writ of habeas corpus was therefore a violation of the suspension clause. And then he voted for it anyway. Now you might say, well, that just shows that, Specter was a bad guy or something, but it's not uncommon for people to enact laws that are inconsistent with even the contemporaneous understanding of the provision. This is, after all, how most people who call themselves originalists explain, is one of the ways in which they explain why they think nonetheless that Brown against Board of Education, and more importantly, Bowling against Sharp, which invalidated segregated schools in the District of Columbia, are correctly decided, notwithstanding the fact that shortly after adopting the 14th Amendment, Congress enacted laws that provided for racially segregated schools in the District of Columbia. And so the reliance on whatever laws existed at roughly the time of the adoption of an amendment is not necessarily originalist. It could be consistent with the original understanding. It could be evidence of it, but you need an additional step. And one of the additional flaws, I think this is consistent with Josh's critique of Bruen, is that Justice Thomas doesn't provide that. Okay, so I don't think Bruen is originalist. I also don't think it's consistent with how the court applies history and tradition and original understanding, even when it does so in other contexts, including closely related contexts. So if you look at Heller, one of the things you see is that Justice Scalia consistently draws sort of analogies, not the kind that Justice Thomas wants, but he sort of says, well, look, we wouldn't do this with respect to the First Amendment. We shouldn't do it with respect to the Second Amendment. Right? He wants to treat the Second Amendment much like the First Amendment. But with respect to just about every other constitutional right with which I'm familiar, the way that history and tradition and the original understanding come in is for defining what the scope of the right is. And then if the government wants to pass a law, you ask two questions. First, does it infringe that right as defined using either originalism or original meaning plus other factors or whatever it is? If it does, you don't typically then say, well, game over, the law must be unconstitutional. There's then ordinarily some kind of very rigorous means end scrutiny, what you know as the compelling interest test, or it could be intermediate scrutiny or something like that. And so it ought to be possible to say that in light of this is the sort of principal point that the Solicitor General is making, in light of the original understanding, there is a Second Amendment right to carry arms in public, and a law that infringes that, like New York's licensing requirement, or more importantly, like the law at issue in Rahimi, will be valid if and only if the government can show that it has a compelling interest and the law is narrowly tailored to advance that. Now, I think in Rahimi, if you did that, you would clearly find there's a compelling interest. There might be some concern about narrow tailoring in light of some of the due process concerns about that were raised during the oral argument with respect to what it takes to get one of these orders. I think in Rahimi's case, it's clear that it was appropriate to disarm him, but there might be other people subject to the Texas scheme who might not actually be a threat of violence, but that would be a due process and maybe a narrow tailoring issue. You wouldn't rule it out simply because in 1791 or 1868 there weren't domestic violence protective orders. So I guess I want to agree that we have sort of low-hanging fruit here. That is, it seems to me originalists ought to be skeptical of Bruin for the reasons we've discussed, and that actually, in some sense, Bruin, if taken by the Supreme Court, as indicative of what originalism is sort of dangerous for originalists, because I think I agree with Josh that it would, it's extremely unlikely that the court is going to strike down or was going to side with Rahimi in this case. And if it were to do so, that would be discrediting to originalism, even though, and I say this not as an originalist, even though I don't think it's fair to sort of tar the originalism with the methodology of Bruin. Okay, I'll stop there because no doubt people have questions.
Very good. I think I agree with a lot of what Mike said. I want to just focus on one sort of historical aspect. Throughout American history, people have often disagreed, right? Mike mentioned an important early incident, which was the so-called Alien Sedition Acts, right? Where basically the Adams administration used the federal government power to punish their opponents in Jefferson's Republican Democratic party. And you had Madison and Jefferson at the Virginia Kentucky resolution saying this is unconstitutional. And there was not really a court case testing at the time. There were some convictions, and judges, including John Marshall, allowed those convictions to go forward, as did Salmon Chase. But there was no resolution. And then when you get to the 1960s, you have Justice Brennan. I think it was in Brandenburg. Was it Brandenburg? One of the cases in the 60s or 70s, they said in the court of history, basically Jefferson got it right. And I think Mike made an astute point. When you're looking at historical debates in which people disagree and you want to pick a side, are you simply saying that we're going to pick the side that we find more agreeable on perhaps policy grounds? Are we saying we're going to pick the side that we think is more consistent with original meaning? Well, how do you know which side that is? I mean, Adams and Jefferson are bad examples. They were both in France during the convention, but they were around. They were in the loop, so to speak. Madison was there. He helped propose the First Amendment in the first Congress. So one of the challenges, I think, with originalism and corpus linguistics and all these other various doctrines is how much sort of weight do you put on different indicia of original meaning? And how do you know which sort of body of evidence to give more weight and less weight? And at some point, that's going to be based on a normative judgment. And that's why I don't want to bring in a friend, but I heard Randy Barnett writes about construction and sort of degree of normativity. The idea is that when you're interpreting the Constitution, you do have to have some sort of principles underlying it, which is where Prelogger's statement comes in. So I think what Justice Thomas was trying to do was well-intentioned, and I think he got 6 votes for it. But I think the court's going to struggle in Rahimi and struggle more broadly of how to be an originalist court. Okay.